Hi, this is Attorney Spencer Cordell. We are going live to discuss dealing with the court system in the time of COVID and the coronavirus, and talking about what all of this means for the courts. They are open, but they are limited right now. How long is that going to last? What do those limitations mean? I'm going to start with kind of some general type stuff, and then kind of filter it down to more specific stuff, specifically for those attorneys who might be practicing. Now that we are going on it, I'm going to try to post some links in the comments for your convenience. And if I fail to get these posted in there now, I will try again later. So these links will get posted in the comments at some point. Sharing the link now, so hopefully you'll be able to refer to those and have some quick references for some of the resources I'm going to be citing to as we're talking about what's going on with the court system right now. A little bit about myself. I'm a practicing attorney here in Lee County. I'm on the board of the Lee County Bar Association. I am board certified in criminal trial law. I've been practicing here, and I do primarily criminal defense. I do some personal injury and occasional other civil-related matters, juvenile delinquency and things, injunctions, things associated kind of with criminal courts as well. I've been practicing here since 2004. I was a state attorney before going into private practice. About 2007, I think, is when I went into private practice and doing defense work. I can see the comments here, so if you've got comments, go ahead and try to post those. I'll try to answer them. I see Stephanie in there, and she had posted a comment earlier, and that'll be one of the first things that we're talking about. So first of all, what has been ordered? Are the courts open, and what are these restrictions right now? So the courthouse remains open. The court has been limited to essential hearings going back a little over a month ago, and most of that limitation is continuing on through the end of the month. Most recently, about a week ago, the Supreme Court, and this all comes from the Florida Supreme Court, they have ordered these restrictions, and then our local courts have been issuing their specific orders that deal with how we're dealing with that in Lee County and the 20th Judicial Circuit. So the Supreme Court has ordered restrictions on everything. They've extended that basically through the end of May. However, the update that they gave us a week or so ago is that they have gone ahead and extended the restriction against jury trials until at least July 2nd. So the previous order restricting the courthouse, most of that is going to expire later on in May. So things will start getting back to normal, or at least what the new normal is going to be. But jury trials still going to be restricted, and that's civil, criminal, and includes grand juries. Those are still under suspension until at least July 2nd. The function of bringing a lot of civilians into the courthouse, into closed quarters, to sit as a jury panel. You're talking dozens of people in a relatively cramped space. Obviously, that's dangerous. That's the kind of large gathering that we're worried about with the spread of coronavirus. So it's not going to be happening for at least another month. What exactly happens after that is still going to have to be determined. A lot of other things are going to be able to be handled remotely. So anything that doesn't require testimony, doesn't require actual physical presence in the courtroom, hopefully a lot of that can be done remotely, even when the restrictions are kind of lifted, just to limit people's exposure in the courtroom and try to make it as safe as possible for everybody. With the suspension of jury trials, the Supreme Court has ordered that the speedy trial requirement is also suspended. And suspended doesn't mean it's canceled, but the time is tolling until at least, and they've ordered July 6th. That's the tolling period for speedy trial. So if somebody is in jail or even not in jail and haven't waived their speedy trial, right now, this time doesn't count against their speedy trial period. And that's under the Florida statutory interpretations of speedy trial. Now, in addition to Florida's speedy trial concern, there's also a federal U.S. constitutional right to have a speedy trial. The U.S. Constitution doesn't specify what time is reasonable on that. So I expect that we're going to see some challenges for people who are, it's probably going to be the people who are stuck in jail and can't get their trials and say, hey, it's been 3 months and that takes it beyond what the normal speedy trial would be. This is unreasonable. That's part of the reason that the orders so far suspending speedy trial and limiting the courthouse have put a definite end date and say right now it's July 6th for speedy trial. They're not making it indefinite, which would, I think, be clearly unconstitutional. But I still think we're going to see some litigation on that as things come up. And then once we get back into doing jury trials, we're going to have a backlog. We're going to have a big problem because there are so many cases that aren't being resolved right now, aren't being tried right now. And when we get back in there, there's only so many trials that can be conducted at a time. That's why it's going to be important to resolve as many cases as we can before July. And it's going to be still tricky with felony cases because you really need to get people in there. But on the flip side, in misdemeanor cases, if it can be resolved, there's no reason it can't be done by a plea in absentia. And so many things can be done in absentia, especially with modern technology. That's something that we're definitely going to need to be looking at. All right, I shared the link. It's probably below me here in the comments section with a bunch of resources. I do want to touch base on some of those. We at the Lee County Bar Association have been trying to share any updates on this web page, all the Supreme Court updates and links to the local updates as those orders have been coming out. We'll keep trying to share those. So this can be a first place to look, because we'll try to share that. But the local, I call it CJIS, that's the county administration page for the 20th Judicial Circuit. They've been doing a great job. They have a Twitter feed, and then they have the main webpage, and that's probably the best website that you can start with, because they link to the Supreme Court. It's ca.cjis20.org. That's the main homepage. And then on that main homepage, they've created a notice page that lists all the advisories for the 20th Circuit and the local memorandums and orders from our chief judge. Plus that, it's got the links to the Supreme Court and all the orders that are going on there. So that is a great resource. Bookmark that. Like I said, it's in the comments here, so you can click on it and follow that link. But that's a great resource. Also, the Supreme Court has a good page on it. It's floridasupremecourt.org/emergency. And that's got a link to all of the Supreme Court orders and memorandums and notices that the Supreme Court has put out, so you can follow that. I'd also recommend the 20th Judicial Circuit Administration Twitter feed. They do an excellent Twitter feed, and they've been great at updating that. As soon as the orders come out, if you're on Twitter, it's at Southwest Florida Courts. It's SWFL Courts. The Florida Bar, in addition to that, their webpage, floridabar.org, and their Facebook page. They've been sharing all the updates on their Facebook page. We've shared some of those on the Lee County Facebook page, so that's a great resource. I try to keep everything, I share everything that's coming out as those updates go as well on my Facebook page, and then on my Twitter feed. That's at Crim Courts. The link is in the comments as well. So those are some great resources. If you have any questions about it, post it in the comments. I'll try to address those as we get on down to it. But all those resources are linked down in the comments, and hopefully that'll be helpful for you. Most of this is going to be focused on criminal courts, because basically all jury trials suspended, criminal and civil, until at least July 2nd. It's going to be real tough to do evidentiary hearings, either civil or criminal. Just getting witnesses in there and doing that, you're not prohibited from doing it virtually, but that's going to be a little tricky for a while. But most other kinds of hearings can be done. For civil courts, the recommendation is that most of these things can be done remotely, be it video through like a Zoom or telephonically, depending on the nature of it. So if you've got an issue that needs to be addressed, a hearing that you want to have, contact the judicial assistant and see if you can set up a hearing on that. Even evidentiary hearings can be done remotely if all the parties stipulate and agree to it. So that's something to talk to opposing counsel, be they civil or in criminal court with a prosecutor. To go through specifically what the Supreme Court order has done right now for in-person hearings, it is limited to essential hearings. What does that mean? Well, the Supreme Court ordered each circuit to identify what hearings are considered essential. And so our chief judge has put out a memo and he's updated it, and they've added some stuff as they realize, hey, we can handle this, listing what hearings are considered essential. And among those are first appearance hearings. That's hearings for people that got arrested the night before for setting bond, letting them know their next court date. Those are still being conducted. Criminal arraignments as necessary, particularly for in custody. I was at arraignment this morning for criminal court. They are trying to do social distancing. So they're only having a couple people in the courtroom at a time. It gets a little crowded in the lobby. They've got spacings and markings on the floor to try to space everybody out to observe social distancing even when there's a crowd showing up. But arraignments are happening. So if you get a court date, an attorney, if you hire an attorney, will know how to be able to resolve that without having to go in person. But if you don't have an attorney, you can still attend that arraignment and they will try to socially distance you. Also essential are motions to set or modify monetary bail. If somebody hasn't been able to post one or they've got a BOP with a no bond, bond hearings are considered essential. Those are still being conducted. For the attorneys who are practicing, file your bond motion and then contact the court in question. They are not bringing defendants over to court for those. Generally, what they're trying to do is to do those semi-remotely. And they've got a few courtrooms that have video capabilities. The jail is not transporting people right now. They're trying to limit that kind of exposure. So they've set up a video system so the defendant can appear over video from the jail. And there are a couple courtrooms that are equipped. They've got big TVs set up, and I've handled a couple of them, and they're appearing by video. And so that's for people who are in custody right now for it to be considered essential. So it doesn't technically include somebody who hasn't, say, turned in on a warrant yet. Juvenile dependency shelter and arraignment hearings, including shelter reviews, those are considered essential. So they are conducting those, as well as juvenile delinquency. They're handling the detention hearings. Those are being done live. They are bringing the children over to court and having them appear in person. I attended one the other day. They're limiting, they're doing them one at a time, limiting, trying to have one parent in the courtroom. The parent has a right to be there, and it's an essential hearing, so it's being conducted. The parent can be there, but they're trying to limit that to one parent. The attorneys can appear if they need to. Those are still going on as they address whether or not those are going to be released on supervision or if they need to be held for secure detention, something like that. Hearings on petitions for temporary injunctions relating to the safety of an individual, hearings on petition for risk protection orders, those are considered essential. Obviously, by the nature of it, it's kind of an emergency hearing. They're evidentiary hearings. They are being conducted live so the judge can have a chance to hear everybody. They're, again, trying to social distance on that. Hopefully we can figure out a better way to do it, because right now what they've been doing is kind of lining people up outside the courtroom. Everybody's trying to kind of space themselves in a line. For people who need to file for an injunction, The domestic violence office on the 3rd floor of the courthouse is still open. People can appear at the domestic violence office, fill out their things. You don't need an attorney for that. And then the actual face-to-face meeting is being done without the attorney. The attorney can go over and appear in that room. And they're trying to limit that contact as much as possible, but the judges are still on duty for that. They're reviewing the emergency petitions and setting temporary orders and then doing hearings on that. That's one of the things that needs to be addressed live, and that's one of the essential hearings. Also essential are hearings on petitions for the appointment of an emergency temporary guardian. If it's an emergency proceeding, hearings to determine whether an individual should be involuntarily committed under Baker Act or Marchman Act. So those hearings are still going to continue to be held. Hearings on petitions for extraordinary writs as necessary to protect constitutional rights. Basically, the emergency hearings there. Habeas corpus, that's going to be included under that umbrella. So if you've got a habeas corpus, those are still being conducted. Habeas can be filed locally. It can also be filed with the 2nd DCA. They're doing e-filing and presumably generally not doing hearings on those. Those usually go on written proceedings anyway. Hearings on petitions for judicial waiver of notice pursuant to section 390.01114 sub 4. Hearings related to the state of emergency for a public health emergency, related to quarantine orders and things like that. And then for jail management purposes, in custody change of plea hearings that may result in a release from incarceration. So that's a get out of jail plea. That's an essential hearing. Those are being conducted. Again, they're doing those like they're doing the bond hearings, that they're not transporting the inmates over from the jail. They're having them appear by video. The attorneys can still appear in the courtroom. If it's a plea and it's a negotiated plea, that's something that potentially could be handled remotely as well by the attorneys. Talk to the JA. You can appear telephonically if everything's been pre-organized. I recommend in doing those, and I did one of those the other day, is trying to get everything filled out in advance. For visiting inmates, you can still do video visitation. The app from GTL, you can actually set up on your computer to do a video visitation on your phone from your home computer and do a video visitation with your client. That gives you a chance to talk over any terms of the plea agreement, gives a chance to go over the plea form. There is a specific plea form being used that has an additional line that says, I waive the right to have this done in person. Now, like I said, inmates are able to appear. They're doing it over the video conference as opposed to being brought over to the courtroom. So the judges want to have that new plea form. If you shoot me an email, I can give it to you. Most of the prosecutors probably will have access to that and can send you a copy of it if you have a plea that needs to be done in custody. I recommend reading it to the client in advance, and if you have time in advance, taking that over to the jail. They're not letting you do in-person visitation right now, but you can deliver documents. So if you get that plea form, fill it out, hopefully you've already gone over it with the client, take it over to the jail, they can run it up, have somebody sign it, have your inmate sign that plea form, deliver it back to you while you wait. They've been pretty good about trying to do that as fast as possible, as long as you're not in a shift change or dining or something, normal visitation hours, basically. They should be able to run that up and get the inmate to sign off on it. Then you can file it in advance, so when the judge goes to call up the system in the case, it'll be in the system. They can look at that, ask the inmate if they've read it. I saw somebody, they weren't able to get the inmate to sign it. They attested in open court that they had individually read it line by line to the inmate, and the judge was willing to accept that in lieu of having a physical signed plea form. I think the better practice is to try to get it signed if at all possible, but that may not be fatal to accomplishing your plea. Now note, this restriction is for pleas that may result in a release from custody. So a judge, and I've seen judges shut this down, if the plea doesn't mean that somebody's going to be getting out of jail immediately, the court may not be willing to accept it. I have seen pleas go through depending on the judge. If it's a definite get out of jail right now plea, time served, you've got no problem. That's definitely included. If it's something that is not necessarily get out of plea, I think that a plea to DOC, to prison, should count. They're not doing any transports right now, but the plea, if it's to state incarceration time, is a get out of jail plea. It means that once transportation is available, they're going to be moved out of there. I have seen judges accept those, so I think that should count, even if it's a plea to state prison time. I would recommend checking with the judge's office, checking with the JA. All of the judges' JA's phone numbers are listed on the CJIS page. They've got a judicial directory on there with phone numbers for all the judges' office. Some of the judges even have notices for advice as to what to do. Judge Gill, for instance, has a separate page linked on the CJIS page for procedures for doing that. And his JA can email you that link so you can look it up and be prepared when you go in there. A couple other jail management necessary hearings, motions to modify a sentence that may result in a release for incarceration. So if you're trying to amend a sentence for humanitarian or health reasons, or something that would reduce somebody's time on a sentence that may get them out of there, that's an essential hearing that can be heard. And then in custody VOP advisement hearings that may result in a plea and release from incarcerations. Still trying to move the non-resolved cases that have inmates that really don't need to be held in incarceration now. So right now they're trying to move as many of those as possible. Those are what's permissible as essential hearings. Now there are some non-essential hearings that can still be conducted, but those should be done remotely. And there's a list of those on that the local administrative order covers. Alternative dispute resolution proceedings should be done remotely. Statuses, case management, and pretrial conference in all types of cases should be done remotely. And a lot of judges have continued those out through the end of the month. I think they're going to start trying to do those in June, but ideally have the attorneys appear remotely. Most pretrial hearings, you can waive your client's presence. Our judges like to have defendants for criminal proceedings appear at pretrial conferences. I would start filing waivers of appearance. I've already, for a bunch of my clients, mailed out a bunch of blank waiver forms, said, hey, sign this, mail it back to me so I can get it signed and scanned and filed with the file to waive their presence for pretrial conferences and things like that. Hopefully, then I'll be able to appear remotely, either video conference or telephonically, and be able to update the courts on that. Not evidentiary and evidentiary motion hearings in all types of cases. So evidentiary hearings can be conducted if they can be done remotely right now. Arraignments, plea in absentia, and county court misdemeanor cases. Plea in absentia is a great way to start resolving cases. And those are specifically included in the local order, so they should be allowing plea in absentias. One thing with the plea in absentias, I understand the clerk is requiring fingerprints. Most types of criminal cases don't have a statutory requirement for fingerprints. If the judge requires it, then you're going to have to do it, but most don't. Theft charges have a statutory requirement for fingerprints. The state attorney's office likes to get fingerprints on, and the judges as well like to get fingerprints on enhanceable charges such as DUI, battery, driving with license suspended, because those can be bumped up to felony later on. They want to have fingerprints in the file to be able to prove that. Not statutorily required, but it's preferred. So those are things that they're probably going to want fingerprints on. Most other things don't require prints legally. Like I said, I understand the clerk's asking for that. I would recommend, and I had a conversation with the JA the other day about it over email, saying, hey, this is something that doesn't normally require prints. The judge wants it. Okay, we'll see about getting prints. I encourage, if at all possible, not to have to do prints, because it's going to be tricky to get prints. I had an out-of-state And fortunately, I knew an attorney in that jurisdiction to call in a favor to get this guy to do his prints. So hopefully we can get that set up. But requirement for prints is going to make it it's going to slow things down when it's not something that's legally required in most cases. Check with the prosecutor, check with the JA to see if the prints might be waived. If the judge requires it or if it's statutorily required, then you're going to have to go get prints in order to get that plea in absentia to go through. Still a couple additional things that are permissible. Hearings in juvenile delinquency cases, that would include beyond the arraignment and detention hearings, can be done remotely. Hearings in non-criminal traffic infraction cases, they suspended a bunch of those through May. I think they're going to plan to start doing hearings on those, and I understand that the courts are working to try to figure out a way to do that remotely. It's one of the things that's specifically listed, and so that's something I think we're going to see is traffic court hearings conducted remotely here before too long. Problem solving court staffing, that includes mental health court, drug court. They want to do those staffings and be able to do check-ins and to be able to do that remotely. So if you've got one of those, check with the attorneys on the other side who are handling that. They're looking for ways to get that set up. That includes hearings, wellness checks, but hopefully those will be able to be done remotely. And then non-jury trials in all cases except criminal, juvenile delinquency, and termination of parental rights for dependency cases, unless the parties in an accepted case agree to the remote conduct of a non-jury trial. So civil, if everybody's on board, it looks okay. For criminal, you can do it if everybody's on board, and it looks like our local order restricts that to kind of exceptional cases. So check with the judge on something. That might be something you want to do a remote status hearing before trying to do it, before you line up witnesses. The Supreme Court order dealing with suspensions and jury trials and everything like that has specifically allowed for people to be sworn in remotely, and that counts for depositions as well as hearings and things like that. So it's not required to swear in a witness in state for them to be, as long as they're in state, they can, if they can appear on video and be identified, they can be sworn in and then testify for something like that. So it's going to be tricky to do trials, even on misdemeanor non-juries, without having your witnesses there. How do you cross-examine somebody? How do you show them documents and say, look at this prior statement, functionally? But it's permissible if you can figure out a way to agree to that. And there are certain circumstances where that may end up working. So I talked about getting waivers wherever possible. Our county court generally doesn't require written waivers. I don't think they're going to get any stricter about that while that's going on. You may want to do it to cover your butt, and that's in Lee County. Other counties do require written waivers for pretrial conferences for misdemeanors, so it's good to have it. Start now, getting them signed and getting them filed. Do that for felonies as well. Judges are going to be interested in trying to conduct pretrials remotely, so they hopefully can just make a telephonic call to the attorney and be able to conduct it in that manner. I understand that some judges are talking about not requiring a signed written waiver. So that is, if you can't get something to your client and get them mailed back or signed fast enough, still go ahead and file a written waiver with the clerk, so there's something in writing there, and the judges may be willing to accept that as a written waiver. Ideally, you want to get it signed, but we have to expect a little bit of flexibility right now because of all the challenges we're having with COVID. So get written waivers in all of your cases, basically, just to cover your butt on something. How do you set up a hearing? We're still going to be kind of feeling this along as we're going along. I've talked a little bit about it. So if you've got a plea in absentia, if you've got a bond hearing, try to get as much of the written paperwork done in advance as possible, and then contact for criminal, contact your prosecutor, make sure they're on board with it. Say, hey, can we do this remotely? I got everything filed. Check the plea form, make sure everything's, I had something, and then fortunately a prosecutor's on the ball and said, hey, they want this special plea form for felonies since it's being conducted by video. They sent a copy of that over to me. So get everything lined up, contact the judge's office. They are scheduling hearings and so forth. as a note, there is a new schedule for the regular things that are going on: detention hearings, arraignment hearings, first appearance hearings. That is available at the CJIS webpage, ca.cjis20.org. They've got a link to the calendar on there, on their notice page. Also, the clerk has a page with the current county court calendar listing all those times at leeclerk.org. Click on her notice page for abbreviations. I think I definitely have the CJIS one down in the comments. I think I've got the clerk's link in there as well. It's leeclerk.org, and they've got a specific link to that as well. And I see we got a couple of comments. Oh, hi. Sorry, that didn't pop up in my feed here. I'm not personally aware of any evidentiary hearings that have been conducted, but it is permissible under the order. So if basically everybody's got to agree before any kind of evidentiary hearing is conducted. So both sides or any parties in the case, and then the judge as well. I did do an expungement hearing, which technically is evidentiary, although it's just documentation. We had the certificate, we had the petition, we had the affidavit, which had been signed and notarized. We filed all that in advance, so the judge was able to just pull it up, say, all right, so here's the certificate, here's the notarized affidavit, everything's in order. Fortunately, the state wasn't objecting on that one, so there was no dispute. So it was basically uncontested. That might have helped it go more smoothly. So I was able to do an expungement the other day. And for orders for things like that, they're in the e-filing portal. There is a section where you can file proposed orders. So we had drafted for the expungement, we had drafted our standard expungement order in advance, shared it with the state, and then filed the draft of the proposed order through the e-filing portal. The judge was able to pull it up and say, meets my approval, and he was able to sign it or e-sign it and get that verified. So that was doing that. To the other question, are they doing video conferencing? I understand that some are. I haven't appeared at any of those myself, so I don't know which judges might be. For a lot of things, they're trying to do it telephonically. If it's not evidentiary, there's nothing disputed about it. If it's pretty straightforward, just doing the phone call. But I understand that they've been looking to set up either Zoom or other means. Check with your judge. The judges are going to know. Every judge is going to be different on that. And so definitely every case is individual. So see what the judges say about doing that video. Ultimately, I mean, if you're going to be having evidentiary hearings or potentially trials, I would, and to swear somebody in, if my reading of the Supreme Court order is that they have to be identified by video, that is the person swearing them in. They don't have to know them personally, but they have to be able to see them and say that's the person who's talking. So I think you're going to need video conferencing for for any kind of evidentiary hearing or something like that. I think video conferencing is going to be required. And so they're looking to set that up. Like I said, I haven't done any yet. I have appeared in person in the courthouse. I try to practice social distancing. I wear a mask out of courtesy. It's not going to protect me, I know that, but I try not to touch my face. I try not to cough, and I wear a mask just not to be on the chance that I might be infected. I'm not aware of any contact, but it's a courtesy to others, just trying to do that mask when I'm at the courthouse in particular, because that's where you get into closed quarters. That's where you get crowds, and that's where, you know, big courtroom things like docket soundings and case managements that get a lot of people in there. We're going to need to rethink that. There's no reason it can't be done remotely. My suggestion on a lot of those, as opposed to setting everything at 8:30 and 1:30 and setting all your cases in a big block, time it out. Set a couple of cases and then 15 minutes later, set a couple of cases and then 15 minutes later. And hopefully that'll allow the attorneys who are appearing to know when to expect a call from the judge. It's not as convenient for the judges not to have everybody in there, and if they're burning through stuff, okay, next case, but you don't want to have people sitting around for hours on end when they're not in the courtroom, not being able to get their work done. It's just not necessary. So it's not the most convenient thing, but if we space out that scheduling, that should help a lot in convenience for everybody else, and in facilitating appearing remotely for things like that. The courts have also allowed status conferences. The idea there being that if the parties aren't too far apart, that potentially it's kind of like the old plea conference. The thinking being that the state isn't quite doing what the defense wants it to, but they want it to be a plea and they're not too far apart, that judges may be able to mediate those. And I think that's okay because it's not being initiated by the judge. It's something being brought by the attorneys on the case. And depending on how it's done, that should work, and that may be able to be done remotely as well. Transferring of cases. This might be a way to resolve some cases because jails are not transferring between jails. They're not transferring between counties. And the Supreme Court orders, all of them, going back to the first one, have recommended doing a transfer of cases. Basically, there's statutory provision for transferring a case. We don't usually use it because it doesn't usually make sense, but right now it does when people can't be brought up. If you've got somebody in jail in another county and they have a case, say here in Lee County or vice versa, you should be able to transfer that case. It needs the party's consent. So if you've got a plea that's going to be a get out of jail plea for a VOP, they got picked up on a warrant in another county, talk to your prosecutor, say, hey, can we work this out? If you've got the terms of the agreement, say, hey, would you object to transferring that case to another county? And so the logistics are going to be a little tricky, and I haven't pulled one off yet. I'm looking into it. There is a statutory provision that consent should be done in writing. So either mail, if you got a client in custody, mail it to them. If you've got time, if it's not a get out of jail right away situation, a consent in writing. See if you can get them to sign off on it. Email it to your prosecutor. One of the prosecutors on my case had done one before, was nice enough to give me a sample on it. If you email it, I can pass along a sample. I've emailed it to a lot of people so far. Get the inmate to sign off on the transfer, get the state to sign off on the transfer, ideally go over the plea form and everything. So everybody's on the same page, but there's no reason that plea cannot be conducted in another circuit and just enter the plea there. And if it's a get out of jail plea, that way you can resolve cases from here, get them out of custody over there if everybody's in agreement to it. And so that may be a way to move cases without waiting indefinitely, because we don't know how long it's going to be before the jails are able to start doing transfers and things like that again. So look into transferring your cases. The thing to note is the statutory requirement for written notice of consent. Florida statute 910.035 is the statute on that, but it's doable. It's doable, and that may help you resolve some cases now while everything's a little bit tricky. Talk about visiting clients in jail. Check out that app. You can do it on your phone. You can do it on your computer. You can go over your plea forms. Then you can have also for transfer consents. That's something you can, like a plea form, appear at the jail, give it to the inmate, they're usually the movement corrections officers are the ones handling it. They can run it up, have your inmate sign it, deliver it back to you while you wait. It may take a little while, but that's probably the most efficient way. Then you can get it filed and done right away. Talking about crowded courtrooms, ERC, Early Resolution Court. I know Judge Starnes has included me on some emails. He is working hard to try to figure out what we're going to do with ERC court when we come back, because we don't want to have just courtrooms full of dozens of people waiting around. So Judge Starnes has been working hard with several other people from the state, from the PD, to try to figure out logistically ways to do early resolution court. Diversion cases there's no reason we can't do those remotely. And I understand that the Department of Corrections has already gotten started with signing people up. You'll need to get obviously the contract. You need to sign that, go over it with your clients, and then that packet with it's basically their initial report that you would have them fill out and sign and hand to Department of Corrections or Department of Probation when you sign them up for your diversion. We normally do that in the little side room at the courthouse by the courtroom there. There's no reason that can't be done in advance too. So you can get that packet, you can get it from the ERC prosecutors if you don't already have one, and then the video, they've got that available on a DVD. They can burn that for you. You can mail it, or it's big to email, but give it to your clients in advance. They can watch the video, they can fill out the packet, with their info. They can sign the contract, and then you can get them signed up remotely. And I understand the Department of Probation is accepting remote signups. Once they get those contracts and the paperwork, they'll contact your client about, and from the information in the packet, telephonically about setting up that initial meeting and instruction and everything like that. So there's no reason we can't start weeding out some of those diversion cases that would be an ERC. If it's one of the pleas I did was it going to be an ERC case, but they were willing to make a probation offer. I had to set that up with the track judge that it was assigned to, and we did it over in courtroom 4A because that's the one that's set up for doing video conferencing. The inmate appeared, and we did a plea to what would have been an ERC court with the track attorney over the video, and we're able to get it through, and the client was able to get out of custody. Once he got out, he did have to go check in with probation. I believe he had to do that in person, so they are doing in-person check-ins, which I'm sure they're trying to limit that, but they will have to check in person. So ERC, they're looking to make more changes. One of the things that's been suggested was time scheduling to divvy them up over a longer period of time, as opposed to having everybody appear at again 8:30, 1:30 or something like that, to try to space it out and not have as much stuff in the courtroom. But they're looking at that. That's one of the things that's being worked on, and I know Judge Starnes has taken some initiative, and I appreciate his efforts on that. We talked a little bit about bond motions before that. Since it's an essential hearing, it could result in somebody getting out of jail. Obviously, you don't know the result until you go to the hearing. I've had one that was denied. But the judge gave me a hearing on it. You're allowed to set that, and the fact that jury trials have been suspended at least until July might be something to consider, depending on the facts and the circumstances of the case. I think that goes into the totality of the circumstances on cases as to whether or not that could be considered. Talked about plea in absentia. That's a great way. Again, talk to your prosecutors, see if you can work it out, see if you can get them set up. So, when next month gets started and we're trying to do things, we're going to have a big backlog. And the more stuff we can move in advance, the more helpful that's going to be. Ran into something on a DUI case for somebody who was looking to get a driving permit and needed to get their driving history. I understand the clerk is not doing face-to-face now. You might be able to request that and have it mailed to you. leeclerk.org is where you can find out about that. So it's tricky right now on a time crunch if you're trying to get a driver's license restriction or driving license record, and you don't want to wait for hopefully for it to come in discovery. The tax collector, which has limited driver's license services, they have some limited face-to-face right now, and I think you should be able to get a driver's license. You have to. They're doing it limited one by one. You have to schedule in advance. So if you go to their web page, or your client goes to their web page, they can schedule an appointment to go down there and appear. And with the fee, which is $22, $25 or something like that, they should be able to get a copy of their driving history from the tax collector. If you go to and I put a link in the comments to the scheduler for the Lee County tax collector. And if you go there, they've got a list of what several offices they're doing. They have appointments available at several offices, so you can pick which office. If it's time sensitive, look at the other offices. When I checked it out the other day, the downtown office was booked up for a couple of days, but Lehigh had availability on the next business day, and so I shared that with my client, and they were able to get had the opportunity at least to get signed up to try to get their driving record from the tax collector. So great job by the tax collector of making that available. And maybe, like I said, the clerk has some limited services. You may have to do that by mail, though, and it may not be fast enough under that 10-day window looking for driving permits. Speedy trial, talked about that a little bit. Speedy trial now has been actually suspended beyond the trial suspension period. The speedy trial has been stretched out or suspended until July 6th. It's being told, so that clock is not running right now. I think we're going to see some litigation when people go to challenge that. Their challenge may not be under the Florida statutory speedy trial, rather the U.S. constitutional speedy trial. So there's two ways that can be attacked. I'm not aware of any litigation on that yet. I haven't seen anything come down. But I suspect we'll see something like that in the meantime. I believe they also suspended speedy trial for civil traffic violations. I don't think that suspension has been continued till July. So I think that's going to run out at the end of the month. But like I said, they are looking to start doing civil traffic infraction hearings next month. So you may be able to get your hearing on that. And then there's that period was told. It wasn't in the initial order, so you have to go. If you've got a speedy trial issue on infractions, I encourage you to go back and look at the orders and see exactly when it started. It didn't start initially. They added it on one of the amended orders with that. How are we going to do jury trials when we come back? And I don't have an answer to this. It's going to be tricky because the trickiest thing that we can do right now is get a whole crowd of people stuck into one room. Jury panels, which generally, on a felony, you're talking dozens of people that you normally need to go through. Maybe we need to figure out a different way to question, as opposed to putting our veneer in one courtroom and sitting one. Maybe we call them in one at a time. That I heard somebody talking about it just today. Apparently, there's about 400 seats in our jury trial panel room. Obviously, they don't want to fill that up. I've seen it filled up. It's been dead quiet for the last several weeks. But maybe they can find more space, gets our potential jury panels spread out, and then call them into the courtroom one at a time, which is not what we're used to doing on most kind of jury trials. But that may make the most sense once we're able to get back to it. Again, jury trials are suspended until at least July 2nd. But we're going to have a backlog, and it's going to be tricky, and people aren't going to want to come in for jury trials right now. So that's one of those still remains to be seen. Let's work with our judges and see what can be done about it. Depositions can be done virtually. The court order authorizes virtual depositions. That we've talked about how people can be sworn in remotely over video. And the initial order has already started allowing remote depositions for law enforcement. And I believe that will extend at the end of the month when this order expires to allow other depositions to be done remotely. I know several of the court reporters in town have equipment available to be able to do that. So again, it's going to be tricky. How do you question somebody about some documents? It's going to be a challenge. It just is. But we don't want to avoid a backlog. And so judges are going to start doing case managements and pre-trials next month. And they're going to say, hey, that court order allows remote depositions. Why haven't you started doing those? The state's working remotely. They're working from home, but they are available. So you need to start scheduling those, if not getting those done, because the judges are going to start expecting that. So definitely start looking into doing your depositions, particularly law enforcement depositions remotely, where possible. Something worth pointing out, there have been a lot of CLEs available online, a lot of free CLEs. The Supreme Court has extended the reporting requirements for free or for your CLE hours, but there's a bunch of them online right now that you can download and just watch for free. We didn't do a credit for this one in part because there's a lot of things already out there. If you're a member of obviously you're a member of the Florida Bar, for all the attorneys down here, but if you're a member of the section, a lot of sections are trying to do some free CLEs. The criminal law section has done a couple of those already. I think 3 of them. I think they're available online still for free under the criminal law section page of the Florida Bar. Jason Blank, who I know, did one of those. It was a good one. If you're a defense attorney, if you're a member of FACDL, the state Florida Association of Criminal Defense Lawyers, they're doing some free CLEs for their members, and they've got some discounts. The Florida Bar also has their partner Legal Fuel has a bunch of those. I put a link to Legal Fuel and their page down in the comments. There's quite a few hours. I just glancing at it was 6 to 10 available free hours on there. and a lot of them are actually specific to practicing remotely, running your office remotely, appearing remotely, and things like that. So some relevant kind of stuff while we're doing this right now. So free CLEs that are available, that's just something worth checking out. Again, resources, I tried to link as many in the comments as possible. The clerk has a calendar up at leeclerk.org with how everything's running right now. That's a good place to go for their resources. Again, the number one resource is the CGIS page, ca.cgis20.org. And on their homepage, you can link to their notice page. I put the link to the notice page down in the comments, but that's a great resource. It links to all of the local orders. It links to all of the Supreme Court orders. That's a fast reference page to, if you need to go back and look at that, you can do so. A couple of our sponsors are talking about depositions, and somebody from the bar posted that in there a second ago. Fort Myers Court Reporting, I believe they are doing remote depositions. U.S. Legal has some resources available, so they're worth checking out what they've got. The Florida Bar Center for Professionalism has a guide for professionalism in the electronic age, and it's specifically dealing with COVID stuff. It's https://t.co/v. I think it's a zero, not an O, V0XHDZPV, capital VE. I put the link down in the comments to that one as well. It's just a 3-page guide that you might find handy for practicing with professionalism. Also, the Florida Bar has sent up a mental health hotline. A lot of stressors going on. If you need a resource, somebody to touch base with, give them a call. It's 833-FL1-WELL, FL1WELL. That's the Florida Bar Mental Health Hotline. I've been talking mostly about state courts here, kind of similar situation over at the federal courthouse. The Middle District has suspended jury trials through at least the end of May, and I think they're limiting grand juries as well. And through the end of May, hearings are restricted to remote hearings. That means telephonically. Their webpage, I don't know if I linked that one, is the Florida Middle District, flmd.uscourts.gov. That is flmd.uscourts.gov. Or if you Google Florida Middle District, they've got a link on there to their notice page as well. And if I didn't already have that one in the comments, when I get done here, I'll try to post a link to that in the comments as well. But that's what's going on in the federal court. So they're restricted as well, kind of going parallel to what the state courts have been doing. That's actually governed by part of that's governed by the CARES Act that does resources for small business loans and everything like that. The practicing with professionalism link that I talked about, and there's a CLE on the Legal Fuel link that have some more information about those, and you get some CLE credit for it on the Legal Fuel one as well. All right, wrap it up on an hour. Let's see. Family law court judges. I don't practice in family law court, but that's going to be under kind of the civil umbrella, is that hearings are restricted to remote. You can do an evidentiary hearing if everybody agrees. I recommend talking to the JA and say, here's what we want to do. Can we have a hearing on that? The courthouse is open, and they're trying to, particularly with family court, trying to move that stuff along. So hopefully, particularly if it's non-evidentiary, you can definitely do it remotely. Evidentiary is just tough to do, but if everybody agrees under the court order, you can do it remotely. And I don't practice in family law, so I haven't dealt with the individual judges on that, but it's definitely something worth reaching out to each of the judges individually and seeing what they're permitting individually. And basically, if it can be done remotely, try to do it. They're trying, the judges want to keep busy. They know there's going to be a backlog, and they want to try to move as much stuff as they can. So reach out to the JA and see what can be done. Thanks for paying attention. If you have any additional questions, you can put them in the comments. If I see them after this is done, you post it later, I'll try to respond in the comments. You can shoot me an email, SpencerCordell@hotmail.com. Follow my Twitter feed @CrimCourts. And you can direct message me or something on that, or on Facebook. I tend not to see the Facebook ones as well. If you're on Facebook, just post it in the comments here. I'll keep coming back and checking the comments on this to try to answer anything that might come up. If you've got a specific question, a lot of specific questions are going to be judge specific. Talk to the judicial assistant for each judge and say, here's what we're hoping to do. Can we do that? Thank you to the judges. Thank you to the judicial assistants who have been working so hard and are continuing to work hard, because we're going to have a new normal. We're going to have a lot more remote appearances. It's going to be tricky, and we're going to have a backlog because some things are still happening, but we're just not being able to move cases like we would want to right now. So good luck to everybody on both sides, defense, state, and the judges and their assistants as well, as we try to resolve things and move smoothly as possible as we try to get back to the new normal. I want to shoot out a special thanks to the board of Lee County Bar Association. They've been working hard to serve everybody and trying to do some remote meetings and things like that. Check out follow our Facebook page if you don't. Definitely join Lee County Bar Association if you haven't. We do have CLEs available as well. We've got our library, and we're working remotely, but we can try to set something up to get those to you if it's something that you need some CLE reporting hours or something like that. The phones are working. You can call the Lee County Bar Association office if you have additional questions. Shout out to and thank you to our Chief Judge, Judge McHugh, and everybody that's been on the committee dealing with that. They have been meeting on a weekly basis as they're trying to sort that out. The judge has been taking comments from the state, from the PD, from court administration. A shout out to Danielle O'Halloran, who's been the private bar representative on that committee and going to all the meetings and keeping us posted. I've been trying to share them on here. The bar tries to share them on here. So we'll try to keep you posted on that as well as possible. But thank you to the judges, the admin. I mentioned Judge Starnes before, and everybody on his committee that's been trying to figure out the best way to structure things moving forward and to make it move as smoothly as possible, because we're all dealing with a lot. Good luck to everybody, particularly those in private practice, because it's hard out here. I'm at the office now, but the door is locked, and I'm trying to do everything as much as possible remotely by telephone or video conference, and just trying to social distance. And I hope everybody is as well. Stay safe out there. Thank you for your attention on this. Like I said, if you have any more comments, try to put them in the comments. I'll try to answer any questions. I will attempt to post this online, so if you didn't get to come in at the beginning, hopefully if I can get that posted here on the Lee County Bar Association Facebook page, we'll make it available so you can check it out and go through in case you have any questions or didn't get to see the whole thing. Thanks everybody for paying attention. Thanks for everybody who commented, asked a question. Hopefully I answered those as best as possible. I appreciate it, and we'll see you. Good luck going forward. Everybody stay safe out there. Thank you.